Hello, once again, welcome to the Law Professor channel. In today's presentation, we shall be looking at another aspect of vicarious liability. And in this context, we want to look at vicarious liability for the acts of independent contractors. Vicarious liability for the acts of independent contractors. Don't forget to subscribe to this channel, share the video, and like. Okay, so vicarious liability for the acts of independent contractors. We've established that generally an employer or a master is not vicariously liable for the tort of his independent contractors. They are generally not liable for the act of for the tort of the independent contractor. So that is the premise from which you are expected to start a discussion on vicarious liability for independent contractors. But um, so every general rule, we usually have one form of exception or the other. So this is not different. This is not different. You would have vicarious liability sometimes by employers or by master for the act of independent contractor. So that is essentially what our learning outcome is today. To know the meaning of independent contractor and to appreciate the rules of vicarious liability for the act of independent contractors. An independent contractor, we've said, and we'll repeat again, is someone who agrees to perform a job with his skills and methods without control of the employer to attain results. It brings on board his own skills, his own facilities and everything, does the job and goes away, and you pay for those services. And you pay for those services. And when you've done that, the relationship has ended unless you call that person again. Examples would be you call a ride, maybe an Uber driver, you call an electrician to come and fix something in your home, a plumber, all these people come in and they go. They are not in permanent employment with you. So we describe that relationship as a contract for services, as a contract for services. And by that, we mean that the person comes to render some services to you and goes away. Unlike the relationship between an employer and a servant, which is described as a contract for service. The person is part of your organization. So that general rule, we are repeating it again for emphasis that employer of an independent contractor is not vicariously liable for the acts of the independent contractor. These exceptions then, what are they? As an exception to that general rule, the law says that where the employer was the one that authorized the act that you are complaining of as a tort, then the employer will be vicariously liable. If what you have assigned to the independent contractor to do, if what you have contracted with him to do, it's what in itself constitutes the tort, that employer will be vicariously liable. If, for instance, I told someone to build a house on a piece of land, maybe a building company, and it happens that I'm a trespasser on that piece of land, then I'll be jointly and severally liable for the act of the independent contractor. Employers can be liable where they are negligent in choosing an incompetent independent contractor. So the law as a deterrent, if what you have done shows that you have been negligent in employing, in choosing the person that will do the work for you, and that would be a case of liability for the act of the independent contractor. Then sometimes, there are torts that we call strict liability torts. If what the employer has contracted with the independent contractor to do results in the commission of a strict liability tort, for instance, the tort of under the rule in Rylance and Fletcher, the employer and the independent contractor will both be liable. Then there are duties that the law does not allow you to delegate. So where an employer is under a non-delegable duty of care, no matter who that employer has contracted the duty to, the law still places responsibility on the employer, which may even be described as a primary responsibility. Examples of non-delegable. When we say non-delegable, it means that you cannot delegate the responsibility to a third party. Of course, you may tell somebody to do the work for you, but the responsibility, who is responsible for that work, remains the employer. So, for instance, the employer's duty to protect the health and safety of the employee at place of work, it's a common law duty, which is also statutorily enforced. See the case of Wilson and Clyde Pool and Company against English. That case established the duty of an employer to provide a safe place of work, safe system of work, and other components of the common law duty of an employer. So, duty of employers towards their employees' health at work cannot be delegated. You cannot say I contracted it to an organization to be doing it. So if anything goes wrong, they should be held responsible. No, both of you will be jointly and severally responsible. If your employer has employed an independent contractor to do extra hazardous work, that work also will be regarded as non-delegable. We are looking at employers' non-delegable duty, which he remains liable for. So extra hazardous work, or where there's a statutory breach of duty, those are duties that the law will not allow someone to say, well, it wasn't my work, it's my act, it was the act of an independent contractor. The law will not permit that. So also, where the work of an independent contractor is done over or adjoining the highway, in those cases, these are regarded as non-delegable duties, which employers remain liable for, even when they have employed someone else to take up the performance of those duties. The responsibilities remain on the employers. So these are the situations in which an employer could be vicariously liable for the tort of or the acts of an independent contractor. So, as I said earlier, don't forget to state the general rule to understand the general rule and then to understand the exceptions. These exceptions also form component are founded on principles that the law wants to ensure that it deters some activities and makes sure that if you are going to engage in those activities, then you remain responsible irrespective of the presence or absence of fault. In the next presentation, we shall be looking at another component of vicarious liability.